Hi, I'm Bhavani from the London Law Practice, and today I'll be sharing some ways of making sure your contracts are legally sound and fully enforceable. Keep watching to find out more. Not all contracts are created equal, and the wrong phrasing or a missing clause could mean the difference between a successful or unsuccessful claim. The only way to make your contract enforceable in court is by having an experienced solicitor carefully draft the agreement and by including certain key clauses. Here are some of those key clauses that every contract should have. Number 1. A confidentiality clause. A confidentiality or non-disclosure clause outlines the conditions under which the other contracting party may disclose your sensitive information or ideas. A confidentiality clause should be written in clear, specific terms, avoiding vague language or broad references. Importantly, the clause should clearly define the information which is considered confidential, as well as the repercussions of a breach. To maximize the clause's enforceability, its terms should also be reasonable in scope, particularly with respect to compensation due in the event of a breach. Number 2. A termination clause. Just as a contract must outline the terms of a legal relationship or agreement, it should also include a termination clause stating the terms and conditions under which either party may end that agreement or relationship. The clause should also specify each party's rights depending on how the termination occurs. Number 3. A penalty clause. Penalty clauses provide that any party found guilty of certain contractual breaches must pay a pre-agreed sum as compensation. These are usually included in a contract to deter a party from breaching and to avoid court proceedings. However, penalty clauses are generally unenforceable unless drafted as a liquidated damages clause, which provides a realistic penalty charge based on a legitimate estimate of any losses occurred. Number 4. Written representations and status. A representation is usually a pre-contractual statement of fact or opinion by one party that induces the other party to enter into a contractual agreement. To avoid claims of misrepresentation later on, written representations should be included in your contract detailing the past and ongoing status of any facts influencing or determining the agreement. This is particularly important in purchase agreements. Number 5. A clause about jurisdiction and dispute resolution. Your contract's dispute resolution clause is critical as it will determine where and how disputes will be heard. The provisions of a jurisdiction clause state that the parties are willing to have their disputes heard by named courts in a specific jurisdiction. Particular courts like commercial courts may also be identified if appropriate. In addition, jurisdiction clauses may either be exclusive or non-exclusive. In the case of a non-exclusive jurisdiction clause, the courts named can hear the disputes, but the parties may litigate in other courts as well. In exclusive clauses, only the specified jurisdictions can hear the parties' disputes. Finally, number 6. A clause to limit your liabilities. Limited liability or exclusion clauses can be included in most contracts. Remove liability for indirect or incidental damages, reduce or eliminate the potential for damages in the event of a breach, and exclude certain remedies that would otherwise be available to the non-breaching party. It should also be noted that exclusion clauses do not overrule either party's statutory rights, nor are they valid where deemed unreasonable under the Unfair Contract Terms Act. For more personalized, expert legal advice on drafting enforceable and reliable contracts on a one-off or a regular basis for your business, contact us at the London Law Practice today.